Well, hello everybody. Neil Foley from the Business Growth Club here again, and really delighted today to have James Kidd with me. How are you, James?
I'm good, thank you very much. It's Friday afternoon, Neil, so that's really good.
Friday afternoon, no, absolutely. We've been talking about books and things we love and everything else, but what we're going to do over the next half an hour or so is talk about employment law, because James is a partner at Mills Reeve here in Norwich. In employment law, and what was the other one you said? Immigration and pensions, or pensions and immigration?
So I lead our pensions, immigration and employment team in Norwich.
Who knew there was a pensions and immigration team?
You do now.
I do now, and so does everybody else. So that's what we're going to do over the next half an hour or so. So there'll be some helpful tips there if anybody's listening who employs people or thinking of employing people. I know it sometimes puts people off. It's a bit of a minefield at times. Is that how it feels to you, James?
It can be, yeah. There are some real traps that you can fall down. Certainly. So should we come back to that later and talk about how I came to be what I am?
How you came to be a lawyer. Did you, as a young boy thinking, I want to be a lawyer?
No, I wanted to be an artist. I loved painting, genuinely loved painting.
Wow.
So I'm an Essex boy by birth.
Yep. Whereabouts?
A place called Saffron Walden. Which
is very posh.
Yeah, maybe.
It's very nice, isn't it?
It is very nice. I go back now. My dad still lives in the house I was born in. And Saffron Walden was great, but it felt like a small town growing up. But I was going to go to Harlow, an FE college, to study art. I was going to do a foundation course there, and then I either had a crisis of confidence. There's always going to be so many better artists than me, or my parents thought, actually, are you going to make any money out of this, James, or are you going to be starving in a garret somewhere? Yep. So suddenly I decided to become a lawyer. And now,
what sort of age was that then?
I guess 17, 18.
So you're doing your A-levels?
Yeah. And then I go through UCAS and go straight into law degree at Leicester. And I had a great... I always used to say my degree was my best years of my life. It's kind of hard to say that after you've got married and had kids, because it's kind of true. Disrespectful to your family at that
It's a different sort of enjoyment, isn't it?
Absolutely. I had a great time. And then after I finished my degree, I had worked for 2 years. I worked for the Law Society, which is the governing body for solicitors. And that was brilliant, because that allowed me to know actually how offices and employers work and all that sort of stuff. Yeah. And then went and did my postgraduate course and eventually got a job in Ipswich. So when I was in Ipswich, I was working for a firm now called Goatley's, then called Goatley and Goldsmith. And I wanted to be a family lawyer by the time I'd finished that, because I loved genuinely making a difference. So we were a lot of legal aid stuff, and when legal aid was available to anybody in those days, and we were helping people. And I distinctly remember helping estranged parents have contact arrangements with kids, all that sort of stuff. But I looked at the partner who was in the team there, and he'd seen every permutation you could of a divorce and that sort of stuff. I thought, do I want to be that person? But yeah, I did. I really did. And they said, we really like you, James, but there's no room at the inn for you to become a family lawyer. Do you want to become an employment lawyer? I'd never done a scrap of employment law up until that point. And I thought, okay, I'll give it a go. I qualified 20 years ago, 2 months ago. So that was, quite a long time ago. So I learned about employment law, and then I was acting generally for the underdog, for the person who's just been dismissed or has been treated very badly.
So employees rather than employers?
Yeah, exactly. And my first ever case in the employment tribunal, I was acting for this 19-year-old lady who had been dismissed by telephone by the care home manager after some spurious complaint made by the family of a resident. So we were, in hindsight, always going to win because it was unfair. You have to go through various processes, and we'll come back to talk about that in a minute. And they didn't. They just took the family's word for it and just phoned up and said, you're fired.
Tremendous.
So I took her on a no-win, no-fee arrangement. She didn't have any money. So we go to tribunal. We're in the tribunal waiting room at Bury St Edmunds. And this lady turns to me and says, James, is this your first time in the employment tribunal? Now, this is the start of my obviously glittering, inverted commas, legal career. And I thought, and I had to think very quickly on my feet.
How do you answer that?
Yes, it is my first time. But if I am honest, she's going to be really even more nervous than she was. So I said, no, of course not. We go in. Due to my devastating cross-examination, obviously, we win the case. Afterwards, I say, actually, I thought, I'm not going to carry on my legal career on a lie, and I was completely honest with her, and she said, well, that's absolutely fine. But I'll always remember that moment of, a little white lie might
Yes.
help that situation
Yes,
just
absolutely.
at that particular moment.
Yep.
But
Because was she cross-examined then?
yes.
Oh, I see.
Yeah.
So you're actually in the box, if you like.
Yeah. Yeah.
So it is quite daunting, isn't it? As a
is.
19-year-old, that's quite tricky, isn't it?
Yeah, and the twist in the tail was, having won, we then end up with a situation where we have to go back a couple of months later to determine how much money she should get.
Yeah.
And in the meantime, she's been looking for other jobs, and she rejected one job that she got because it was, she thought, too far away, too far to her to travel. But she went the back roads to this place, and the care home that had fired her said, actually, if she'd gone straight up the road, it would have taken half the time. And the tribunal said, yes, she should have taken the job, so she didn't get hardly any money because she could have taken that job and therefore mitigated her losses.
Wow. That's quite harsh, isn't it?
A little bit, yeah.
Yeah.
But that goes...
I didn't realise they looked at things like that, tribunals. Well, we'll come on to tribunals, shall we?
So that was 20-odd years ago, and I've loved every minute of it ever since. I genuinely love my job. Why? Because at the end of the day, I'm dealing with a bit of misery.
Yes.
Generally, people are doing stupid things to other people, and then they make a call and we get involved. But at the same time, I'm dealing with people. I'm not just pushing bits of paper around.
Yeah. Don't want to be rude to the rest of your profession,
Well,
but
no.
you're absolutely right. You're dealing with human beings, aren't you?
I am. And actually, generally, I'm making a difference. Whether it's... And it's not me, typically, that's dismissing somebody but I'm implementing decisions, but I'm able to make or give guidance, if you like.
Yeah, so they're fair.
Yeah. And a lot of the time, it's not about the law.
No.
My job is about saying, you come to me with a problem, I say, okay, these are your options, this is my recommendation, and you balancing risk, time and cost.
Yeah. And
actually, it's being a trusted advisor, and that's what we do.
Yes.
And I love that. It's not, there was a case in 1836. Who cares? Who cares? It's not about that.
Yeah.
Obviously, it's important. I have to know what the law is, but if I know what the law is and then factor that in when I'm giving you your options, then you go, oh, actually, fine.
Okay, I know what to do now.
Yeah.
So you're acting for employers as well as employees?
So these days it's majority employers. Okay. Sometimes it's individuals. For me, it's important that you do both.
Okay.
I think that there's a point where actually, if you just do exclusively one or the other, you lose a little bit of what would the other side say.
Yes, a bit of balance.
So you need to know, not just being, if you're always acting for the individual, it's hard to get your head around is what will the employer do in this situation, whereas if you do a bit of both. And we are majority acting for employers, but not exclusively. So just recently I had a call from the lady I didn't know, and she contacted me because she'd been referred by X, who had been referred by Y to me. Yep. So she phones me and says, James, you did a great job for this person. I really want you to act for me. I was like, okay, let me take some details. And it was a horrific piece of sexual harassment, sex discrimination against the whole Me Too situation. Yep. I'm thinking, actually, I'd like to help this person. Unfortunately, we weren't able to do so because of what's called a conflict of interest.
Oh, so you already had acted for the employer at some stage?
Ultimately, up the food chain, we acted for the organisation, not providing employment law at that point. But so I couldn't do it, so I referred her on to somebody who I spoke to and said, you really need to do a good job for this person, because it kind of felt I was invested already, only from 10 minutes with her on the phone before I got to the point where actually I realised I can't do this anymore and I have to refer it on. So.
It is extraordinary in today's age, isn't it? That I know from the employment law, when the BBC came out, not that long ago, with discriminating against women. You think in this day and age, how can that possibly happen? I mean, you're probably, you're more used to it, but I look at it and read stuff and think, what? Really?
Well, I in some ways, I'm continually astounded of how people say and do stupid things to their colleagues.
But even institutionally, don't they? So that was at an institutional level to say, well, actually, you're not worth as much as a man.
But people make mistakes. People do something unconsciously. I'm sure the BBC didn't deliberately set out to go, I'm going to pay you less because of your gender. But it happens, and there's that whole unconscious bias thing.
Yes.
But what fascinates me is, I'm going to say something to you because of the colour of your skin or because your sexual orientation or whatever. And if I've not ever been educated that that's wrong, then maybe you think, oh, it's like our parents. When our parents or our grandparents say something which is...
you can't say that.
Yeah, you can't say that. It's kind of,
why not?
Say, well, that's how it was back in the day. Well, but you're still...
That was back in the day.
Yeah, and you're living in today's society. But sometimes living in a middle-class bubble and living in a professional bubble, you can be appalled. It's that echo chamber, isn't it, a little bit? You can be appalled about what people do, but actually... people are people, and we see that with extreme views here and there, and people say things that the majority of people may say that's grossly offensive, you can't say that, but in their head they think it's okay, or as we see with banter, that people get carried away.
Or they're just very powerful people. I mean, that's the Philip Green thing, isn't it? I mean, we wouldn't necessarily talk about Philip Green, but that's the issue. He's a powerful man who, that's just the way he is. He's got a temper.
And there's an element of some people will do what they want.
Yeah, there is. And there's been a law firm, hasn't there, in the news just recently. One of the big London, one of the big Magic Circle firms has been for some sex discrimination. I think a black lady who was pregnant, and when they fired, and they lost the case. And actually, I think the tribunal said that their evidence wasn't credible. Which for a law firm is not actually what you want, is it?
Well, I just saw today, so it's just going on through the legal press today, that there's these two law firms, and one is, shall we say, seen as less big and sexy and exciting heavyweight than the other. And one person is looking out their window, looking across not a large gap, and they see a partner watching porn on their computer screen, and they video it.
Really?
And they send it round to their mates at the other law firm.
As you would.
As you would. And you think, what interests me about not is that somebody is videoing that, because that's fairly commonplace these days, that's what happens, is the mentality. It goes back to the mentality of, I'm at work, I work really hard, and therefore somehow or another that justifies me during the day to just sit there and watch porn at work. I mean, it reminds me of the classic case, and I hope it's true rather than just apocryphal, which is the security guards come in early to work before their shift starts, and they're watching porn using their employer's systems. And when this all comes out, their defence is, but it's not on company time because it's before my shift starts.
And did they get away with that?
No. Funny that. 'Cause you're still using your employer's systems to be able to do this.
Which you shouldn't do.
Yeah, well, so, people do silly things.
So I suppose, that's the example, even if you know the law, etc. So if for the employers who are listening, or listening to this at the moment, James, what are some of the top tips you can give them as to what they should and shouldn't be doing? Well, apart from abusing staff, I mean,
don't do that.
Don't do that. But what should they be doing?
They should be always thinking. We talked about this earlier. It's how would you treat your mother test? I think that's a good test.
It's a very good one, isn't it?
Yeah. So it's about fairness. So actually, if I'm approaching a situation where I'm going to dismiss Fred because Fred's been an idiot, go into it with an open mind, because actually there may be a story about why you think Fred may or may not be an idiot. So rather than just going in and shooting from the hip, actually, if you treat it with fairness, you'd expect to hear what Fred has to say before you reach any conclusions. And employment law is all about process.
Is it?
So classically, you think Fred's been fiddling his expenses, say, or Ginger's been doing something else, whatever. Actually, you may or may not suspend, you may not need to. If you look into that and have a meeting with them to find out whether actually there is some meat to these allegations, that will proceed to a disciplinary hearing. You don't just have trial by surprise. No. You give them in advance all of the information to enable them to prepare for that formal hearing. It's no Perry Mason. And you just produce this magic piece of evidence that shows that person is guilty. They should know what the allegations are facing, and you have a fair hearing, right to be accompanied, and make a decision and give them a right of appeal.
So it's a process that takes a bit of time.
Yeah, but actually you invest that time, you drastically reduce the likelihood of claims coming through. Now, we had 4 or 5 years ago, the government introduced something called tribunal fees, and as a result,
I've heard of those.
As a result, there were big access to justice issues, and the number of claims fell by about 80%.
And this is because if I was feeling aggrieved and wanted to have my case heard, I had to pay a fee
Yeah,
to get it heard.
Yeah, 1,250 quid you had to pay
Oh, really?
in total. You had to pay an issue fee and then a hearing fee.
It was quite a lot of money then, isn't it?
It was, and if you were on the breadline, you got that.
If you were the 19-year-old care worker or
Yeah.
whatever, actually you haven't got 1,250.
No, but if you were genuinely on the breadline, there was a remission scheme. But if you
Okay.
were just above that,
Yeah.
then you still had to pay. And
crikey.
we know, because of the cases that came through, that was wrong and that did put a bar on access to
Who
justice.
came up with that, the Law Society or the government?
No, that was the government,
Really?
because they felt that too many claims were coming through.
It was
which
spurious
were,
claims.
Yeah, exactly.
Right, okay.
And you query, actually, whether that was a sledgehammer to crack a
Yes.
nut of how many spurious claims there were. So
But there's a lot of lawyers in the House of Commons. You'd have thought some of them would have said, hang
Yeah.
on a second.
So fast forward 4 or 5 years, finally that gets overturned, and they're busy refunding all these people that have,
Oh, right, okay.
have had to pay it out. Tribunal claims are now almost back to the numbers they were, but the problem is the tribunal system is broken because the tribunal system is not able to cope with this resurgence in tribunal claims.
Oh.
So claims, if you're an employee and you're going to bring a claim and it's going to be listed for 4 or 5 days, that's probably not going to be heard for nearly a year.
Crikey.
So actually, from a justice perspective,
Yes.
if you need the compensation that the tribunal may
Yes.
award you, should you win, you've got a very long wait,
Yes.
unless it's going to settle, and the majority of claims, of course, do settle.
And could you end up in that situation you said at the beginning, where the compensation I was potentially due is reduced because I've taken some action in that year?
Well, the reality is, if it was just talking about straightforward unfair dismissal, none of the discrimination stuff, if I dismiss you, you're under a duty to fairly mitigate your loss. So you should be out there trying to find another job. That's
Right,
not
okay.
necessarily taking a job classically at Tesco's or whatever, but you're under a duty. So if you go out and find another job at the same level of pay on day 2 after I've dismissed you, you have no loss. You have no, because all the tribunal
Of
can
course.
do is award you the compensation that you would have been due. So
But whereas sometimes, I guess sometimes it's not about money, isn't it? Sometimes it's about the act of justice to have it recognised that you were in the wrong.
I know, but that can be
Yeah.
you're fighting a principle, and who's going
Yeah.
to pay for that?
Wow. So it gets more complicated, doesn't it?
It does. And then when you bring discrimination in, so what we're seeing at the moment, we have a 2-year limit. So you have to have 2 years service to bring an unfair dismissal claim.
Yep.
So whereas if it's a discrimination claim, so there are 9 reasons for, or 9 protected characteristics as they're called, so 9 abilities to say I've been discriminated against. So gender, sexual orientation, disability, age, all that sort
And
of
are
stuff.
they all valid? Do I have to be there 2 years for those?
No, they're a day 1 right.
Really?
So we've seen for years that actually if I dismiss you and you have less than 2 years service, you may say, well, that's because I'm X
Yep.
age or because of whatever protected characteristics. So you were going to try it
Yes.
on, or it's health and safety, or it's whistleblowing, something like that.
Yes.
And then that's gets you into the tribunal system because you can
Yep.
bring that claim. Now, what you will classically do is you also put a data subject access request in. You must have heard of one of those.
Good old GDPR.
Yeah, which they've abolished the £10 fee now. You don't
Oh,
have to
have
pay
they?
the £10 fee. Yeah. And it used to be 40 days for you for me, if I'm the employer, to comply. Now it's a month.
Yep.
So they've shortened the period and abolished the £10 fee. But that is a way of you getting all the information that I've processed on you. So as a tactical weapon, it's
Yep.
brilliant
Yes.
by claimants.
Yep.
For employers, one that you asked me for top tips.
Yeah.
One of my absolute top tips is never say something in email which is later going to come around and bite you on the
Yep.
behind.
Yep. Very true.
And too often, when we get to the disclosure stage, or in response to a data subject access request, you see an email that says, we have to get rid of this person before the process has been started.
Really?
It's just that
Wow.
you may think it, you might say it, just don't commit it to email.
How do
Please.
people know on the GDPR, the data access request, how do they know they've got all the data? Because the temptation is going to say, well, let's get rid of that one.
Yes. So the risk is you say, well, I'm not going to disclose that.
Yeah.
I'm just going to destroy it
Yeah,
quietly.
just get rid of that.
If actually somehow or another they've seen a copy or whatever, or they've got
Yes.
somebody on the
Or
inside,
somebody else.
then the employer's credibility goes through the floor.
Absolutely.
When you say, well, hang on a minute, you tell me you've disclosed everything in response to my request. What about this?
Yes.
And then you're left fumbling.
Yeah.
And it makes you look like you've covered it up.
Yeah. Which you have.
So destroying evidence is a bad thing. And once you've told your solicitor about it, they're under a duty to inform the court or tribunal whether it's good or bad.
Absolutely. You abide by the law, don't you?
Yeah, it becomes very difficult at that point.
So top tip is be fair, do the mother test.
Yeah.
Is that enshrined in law? Because in the financial...
It doesn't appear in the Employment Rights Act, the mother test.
But it's strange it should in a way, because one of the very few things the Financial Conduct Authority have done, though, which is any good, as far as I can see, I can say that because they don't care about it, but you couldn't comment, they had something about treating customers fairly. They came up with this term and said, this is your duty of care, is to treat customers fairly. And very cleverly, they said, we're not telling you what that is, but you know it when you see it. And actually, it is very clever, isn't it?
Rather than going to reams and reams of prescription of this is what we mean by fairness.
Yes. Yeah. To say you know it when you see it. Yeah. And actually, there was a few times fighting on behalf of clients. Actually, you could use that to say, is this treating this client fairly? And they always rolled over because actually it's a very clever test.
So we have the concept of fairness in employment law. And a lot of the time that will be determined by something called the band of reasonable responses. So if Ginger is dismissed, so you may say some employers or the majority of employers would have dismissed Ginger for what she did. But actually, it could be that in your particular industry, what that did is more heinous than other industries. So actually that makes more sense that in that arena, that is seen as more heinous, shall we say. Yeah. So therefore, you would be within the band. And it's an elastic band, and it's a movable band.
And is that moving by case law?
Yes, but it's the Employment Tribunal has got to apply their mind to, would the majority of the employers have dismissed for this? Yes, well then it should be within the band. If actually the majority of the employers wouldn't have dismissed within, and therefore that decision is outside of this metaphorical elastic band of the band of reasonable responses, then it's unfair dismissal, and then you get into the compensation.
And are the employment tribunals manned by professional
person?
Person, is it one person?
No, person. I was picking you up on your sexist comment of man.
Very true. My that generation. In my day, that was all right, James. But so, are they manned by professionals?
You've just done it again, but never mind.
Yeah, I did, yeah. Are they people by professionals?
Yes, so you would always have...
Are they?
Yes, you would, sorry, Neil.
So they're not like magistrates. That's what I was thinking, because the magistrates are largely sort of dictated to on points of law, aren't they? By
a clerk
who's professionally trained.
So in the Employment Tribunal, you'll often have judges sitting alone or judges sitting with lay members. So a judge sitting alone will be a legally trained person.
Okay, so there's always that there.
So they will always have and they are really well trained, so they know what the law is. And then if it's a full hearing, so they'll have a lay member who's from employers, typically from the trade union, and then one from the trade union. So you're bringing balance to the force.
Yeah, that's the idea.
You've got to get a Star Wars reference in.
Are you a Star Wars man then?
I couldn't possibly. Yes, I am.
Are you really?
Don't look so surprised.
Well, you look too intelligent for that, James. But I'm amazed how many people are really into it. Sorry. I'm amazed how many people are into
As a kid, I was fairly obsessed with Star Wars, and I knew so much. And my daughter, one of my daughters has sort of started going the same way.
Oh, really?
And, yeah.
So, were you a Trekkie as well then?
Might have been.
Because I can understand Star Trek in the sense that because they had quite moral stories to them, didn't they?
You can understand the whole concept of a teleporter that's going to somehow take all of the working atoms in your body and replicate them hundreds of miles away on a moving starship. Let's just think about the computing power of that.
Never a problem. It was the stories that were good, though, weren't they? It was because they always had quite a high moral tone to them, didn't they?
Who was trying to do that. And
it was great, wasn't it?
He had a Russian on 60s American TV, so that was groundbreaking.
Yes,
they had the first interracial kiss, didn't they, on Star Trek?
Yes, they did, between
Lieutenant Uhura and Jim T. Kirk.
Yeah. Yes, that's very true.
I'm not ashamed of my science fiction.
No, good for you. I'm glad you've come out. And
thanks.
And any other tips that you would think of? So I hear quite often talking to small employers that I tend to deal with. They sometimes haven't got contracts. Does that prohibit them from following due process? in terms of, as you were saying, you need to follow process. So say you haven't got a contract.
No, that's a good point. So everybody has a contract. If I employ you, you have a contract of employment. It may or may not be written down.
Oh, okay.
If it's not written down, I still have a contract of employment with you.
So it's not right to say, actually, I haven't got a contract.
Yeah.
I have, because I'm doing work in return for
for the wages I pay.
Yes, okay.
But actually, sorry.
Sorry?
I should have turned that off before we started.
That's all right.
Really. Let me turn it off now. If I lose my thread, if I employ you and there is a contract of employment, I can a written contract of employment. I can document where I want you to be, how I want you to do this stuff, and manage your expectations. And I'm therefore clear about what I can legitimately expect from you.
Yep.
If it's unwritten, it's pretty unclear, isn't it? It's
of
just
course,
that you're going
for
to turn
both
up
sides.
and I'm going to pay
I
you.
thought and you thought.
Yeah.
And,
So for small businesses, absolutely, you want to have a contract and you want to have a minimum set of policies, which will basically cover disciplinary, health and safety, maybe internet usage, what you should and shouldn't be doing
absolutely.
at work.
Yep.
What you should be watching on the monitor, or not, as a minimum. As you grow, you may want to think about more comprehensive contracts, because if actually I'm employing you and you're a real asset to me and you're my best salesperson, I don't want you leaving and going to a competitor having trained you up and given you exposure to all of my brilliant contacts. So then that brings the whole regime of restrictive covenants, so post-termination restrictions. So I do a lot of work on that, where you're leaving and going to a competitor. So I may be acting for the company that's trying to protect its interests and stop you going to leave there. Or I'm acting for the company, and I'm doing one just now, where they really are, only way to grow their business is to poach somebody from another organisation. So there it's attacking the restrictive covenants, and the restrictive covenants are all basically nothing, unenforceable unless they are necessary to protect the legitimate business interests.
Is that right?
Yeah.
I'd always thought in my mind they had to be reasonable. So you couldn't say you can't work for another competitor for
Anywhere
10
in the
years
world,
or anywhere in the world, and that's it. Because that's restrictive of trade, is that what they call it? But I didn't realise there was this other bit.
So they all fail unless they are reasonable in its most simplest term. So probably the maximum you're ever going to get is 12 months.
But not only reasonable, they've also got to be
drafted so carefully.
And actually, there's a logic, a business logic as to why you don't. They can't go to a competitor.
Absolutely. So you're looking at 12 months maximum that post-termination that you're going to get. You need to think about, do I need to stop that person from working anywhere in the world, or is there a geographical sphere that I'm going to stop them? The classic is the hairdressers. Who will, there's been so much litigation over whether that person can go from this hairdressing salon to that one, and is that within the city, within yards, within miles, all that sort of stuff, because clearly we follow our hairdresser, don't we?
Absolutely.
So there is so much goodwill connected with it, and customer connection connected with it.
And the whole concept of owning a client always springs to my mind. You can have the legal argument, but actually, bottom line is if the client says, actually, I'm following Neil over here to this new hairdresser, well, that's where they're going to go.
So I guess going back to top tips, my top tips is if actually you've got individuals and you need to protect your organisation, you need to be thinking carefully about restrictive covenants. So you may put them in for deterrent value only.
Yes.
Which is great,
as
long as everybody understands, apart from that individual,
they are. You're not going to actually enforce it.
Yes, because if enforcing covenants and going to court is thousands and thousands of pounds. So, my view is better to have them than not, because without them, you're nowhere. You're relying on something called the implied duty of confidentiality, which is really quite weak. So have them, but always think about actually how much. If I'm going to have the same covenants on the cleaner as I'm going to have on the managing director, it's unlikely they're reasonable, to use your term.
And is that from an employment tribunal viewpoint? If you had unreasonable clauses in your contract, is it a bit like you mentioned earlier about destroying evidence? Does it immediately just set you up as being a bit of an idiot?
Kind of. Well, it's the courts rather than the tribunals that will enforce those. But if you go to the court and you are trying to enforce a badly drafted covenant, well, somebody should have told you before you got in.
The judge isn't going to like.
They're just going to go,
forget this.
So don't do that.
Okay.
We should mention, because as I was told the other day, I'm a cheapie specialist, and So,
yes.
And I do like TREAPI. So for those who don't know, TREAPI is the Transfer of Undertakings, Protection of Employment, open brackets.
Everybody knows this, James.
2006.
Which is, and it's, I can understand when you say 2006, did it not exist before 2000?
1981, and then it was revised in 2006.
I was going to say, because it makes perfect sense if you're an employee and through nothing to do with you, your company's taken over, your rights should stay, shouldn't
yes,
it? And that's in essence what it is, isn't
yeah,
it?
and the classic is I'm going to outsource my cleaning contract because I don't like the cleaners, or I appoint somebody else, but I've got the same cleaners because they transfer over to the new cleaning contractor. Yeah. But TREAPI is one of those things that people run away from screaming because they say, oh, it's really complicated and horrible and I don't like it. Actually, it's the same issues time and time again, but the learning curve to understand what those issues are can be a little steep.
I bet.
But actually, it's great fun.
Is it?
Yeah, I really like TREAPI.
Fun?
Yeah. No,
why is it? No, I'm not looking in amazement, but
yes, you are.
Fun because it's complicated. Or?
Yeah, because it's challenging.
Yes, I can imagine intellectually it's quite challenging, isn't it?
Sometimes it can be quite daunting for if you are going to take on a contract and the outgoing contractor just says, "I'm not playing ball." You are facing. You may get therefore a team of people that will turn up on the Monday morning reporting for duty. So that's not great. So actually, you want to try and get to a situation where you are treating people with respect. We're back to that by ascertaining in advance: are these people? The legal term is assigned. Are they assigned to the contract that's going to transfer? If they are, okay, should they transfer to us? And if so, how do we deal with that?
Yeah.
But actually, is that outgoing employer just loading the contract with all the waifs and strays?
Yes.
So you have to ask some pointed questions, which is where it gets really quite interesting to understand actually who is genuinely the assigned people who should transfer over.
And I guess if you're buying a company, I can value the assets and you can see what's in the bank and contracts and the rest of it, but actually understanding what's happening with the workforce or whatever, if you're going to merge them with your own workforce, it's actually much harder, isn't it?
Yeah, it's all about do the due diligence.
Yeah, because there could be all sorts of stuff. And presumably if somebody then comes out of the woodwork and says, actually, I've been treated badly here, presumably it's the new owner that's liable, isn't it?
Yeah, we call them woodwork employees, funnily enough.
Really?
Yeah, because I talk about classically they're the assigned team. If actually you change contractor or you buy the assets of another company, and then actually at some point somebody says, "Oh, actually, I think I should have transferred." We call that they've come out of the woodwork, and then they say, "I've been treated very badly because, of course, as a result of not transferring, the old employer just washes their hands of them."
Yes,
and I always think, irrespective of the company positions, let's just think about the individuals here whose ability to pay the mortgage and put food on the table for their family is going to be severely affected by this. Let's get this right and treat it and deal with it properly, frankly. Yeah.
No, which you're back to the respect thing you said right at the beginning, aren't you? So it is about having contracts in place, and I guess, dare I say it, James, getting advice, isn't it? Really about if you're thinking of doing something, you're better off knowing in advance what the issues are, aren't you?
I'm not going to be as crass to say you should phone me, but you should. But
you do need advice.
If it's smelly, or you think it could be smelly, take some advice. And quite often, a bit of planning in advance will save a lot of cost and a heartache later.
Yes.
I genuinely believe that. If you're coming to me and it's all gone pear-shaped, there's only so much that me or anybody else can do. Whereas if you come to me and say, I'd like to plan this process, this redundancy process.
Yes.
There's a lot we can do in terms of planning that process to minimise
and doing it
risk.
Following due process.
Yeah.
And I suppose it's a bit like shareholder agreements, isn't it? People often don't have them, but actually just knowing what you're going to do if something goes wrong, you have a disagreement or lose capacity is just huge, isn't it?
Well, so I work with a lot of startups, and the need, if you're employing your mate, and you're going to give them sweat equity or whatever it is, but you don't document that properly, and actually at some point the mate stops doing whatever, or you're falling out, and you don't have that documented, and you have those what are called good and bad leave provisions. You've come across those. Without that, it just becomes very awkward, unnecessarily. And so people moan about lawyers and always just, there's so many words, but they're there for a reason a lot of the time. If they are words such as herein, before and after mentioned, you're going to the wrong lawyer.
Yes.
Yeah. Frankly,
Yes.
plain speaking is absolutely what you want to be. Unlike me, who mangled the definition of choopy earlier.
No, not at all. I mean, that thinking is... I read in the paper this morning there was, the letter that Theresa May has been leaked about the backstop to the backstop. Have you seen that?
I only saw the headline.
Yeah, I read a bit more about it, and it was the letter that she sent to the DUP, not the DUP, the Ulster Unionists, saying you'd had to read the letter about 6 or 7 times to actually get the true meaning, because what she said and what she meant were two totally different things. You had to really read between the lines and thinking, actually, I would have read that something totally different.
I read I love libraries. I'm a bibliophile. We touched on this earlier. And I read, and there was a petition. I signed a petition that said we must do more to keep libraries open.
Yep.
Where else can you just go completely on trust
Yep.
and get an item of value? Okay, a book's not that valuable, but so I signed an electronic petition to try and get more support for our libraries. And I saw the response today that came back via the government. You just read it and think, that is just full of nothing. That is just hot air.
Yes, Prime Minister, all over again.
Yes.
Absolutely.
Yes, Prime Minister. And just sometimes there is a real value to plain speaking, rather than just filling 3 paragraphs with nothing, and it's just management jargon.
Well, isn't they always said that? I mean, I don't know whether this is true, but the law was always you were paid by the word.
Yeah.
Hence, partly superiority and intellect, and there was all of that stuff, wasn't there?
It was.
But whereas the law now is far more, as I say, modern lawyers like yourself are going to be far more about plain English and understanding, isn't it?
Well, if I can't write you an email that actually tells you what you need to know and gives you my advice, and you have clarity and certainty on costs, then I've not done my job properly.
Yeah.
If you instruct somebody and you have no idea what it's going to cost, and you don't understand the communications you're getting back, find somebody else.
Something's gone wrong, isn't
Yeah.
it? No, something's gone wrong. Well, we could talk for ages, James. We've been over 36 minutes, would you believe? So.
I can't see. I believe that's.
You're looking at the clock. You see, I'm not looking at the clock. You've made the law sound really interesting. So I think you've risen to the challenge, James.
Thank you.
And I guess it is, because it's about people and everything else, isn't it? And the interaction and just protecting people. So how do people get in touch with you, James? What's the best way for them to find you?
There are perhaps 3 ways.
Okay.
So you can look at Mills & Reeve's website, millsandreeve.com, and I'm on there. You can find me on LinkedIn pretty easily.
Yep.
And I'm also on Twitter at James Kidd Lawyer. And I have to say, I absolutely adore LinkedIn and increasingly Twitter. I've been on Twitter for years, but that was in a personal capacity, and I've just moved in a work capacity.
Okay.
Just for the dissemination of information
Yes.
and the way you receive information, I have to say, I think social media is great.
It's got much better, isn't it?
Yeah, and I really like LinkedIn.
Yeah. No, I think there's more and more people, I think, actually engaging on LinkedIn as Facebook has declined in sort of its usage, and the young aren't on Facebook anyway.
No.
But actually LinkedIn is really powerful. Well, I really appreciate your time, James.
I really enjoyed it, Neil.
Yeah.
You're a very good host.
Well, thank you very much. You're a smooth man. Thank you very much, everybody. So this will be up, and get in touch with James. You won't go far wrong.
Thank you.